Right now in this picture, we're going to continue in delivering the lecture about commercial law for business students for Al Isra University. We are going to talk about duty of parties of the contract, which means the sellers and the buyers. We first are going to talk about the duty of the seller himself as a part of the contract with the buyer. Duty of the seller, duty to deliver goods at the right time. The right time means not before, not after, the right time, or the agreed time, or the contractual time, which agreed upon in the contract itself. Delivery is the voluntary transfer of possession from one person to another. It does not necessarily mean transportation. Transfer of possession may be actual or constructive or conceptualized as legal possession. Stipulation as to time is of essence in the contract of sale of goods. The court held that in ordinary commercial contracts for the sale of goods, the rule is that time is prima facie. Prima facie means in the first instance or the actual or apparent. Prima facie of the essence. Again, prima facie means in the first instance or actual or apparent of the essence in the contract. If the time for delivery is fixed by the contract, then failure to deliver at that time will be a breach of condition, that to deliver on time, where no date is fixed in the contract. Delivery by the seller must be within a reasonable time, 1 week, 2 weeks, whatever, according to the contract and according to the goods. Reasonable time, which will be determined by matters such as the nature of the goods. If the goods actually ruined, so we have to, or the seller has to deliver the goods on time. Otherwise, they are going to decay and rotten. Although time is of delivery, the buyer can waive this condition. Where he does, then it will be binding on him, whether made with or without consideration. Now we are going to talk about duty to pass good title. This is a condition of the contract for which the buyer can terminate the contract and seek damages for any loss, or affirm the contract and recover damages for loss of the goods, of course. The right of the buyer is to receive the best title to the goods. That is title that cannot be defeated by another person. Duty to supply goods for the right and satisfactory quality. Duty to supply goods of the right and satisfactory quality. There is usually an implied term that the goods supplied under the contract are of satisfactory satisfactory quality and correspond with the description. Goods are regarded as sold by description, where the buyer contracts to buy the goods in reliance on the description given by or on behalf of the seller. So the seller has to be honest and tell the truth about the goods, and his description fit on the actual goods. Recovery of the price. Recovery of the price. If the buyer has paid the price, he may sue the seller to recover the amount paid if the goods are not delivered or the consideration for the payment has failed. This is his right, of course, the buyer's right to recover his price if the seller breach the condition or the contract. The case of rejection of the goods, the buyer can repudiate the contract if the seller is in breach and the breach goes to the root of the agreement, to the essence of the agreement. That is, the breach is a breach of condition and not warranty. Breach of contract may arise in the following ways: late tender of the goods, breach of an implied condition, right of rejection by virtue of an express or implied terms or usage of trade. We are going to continue. The case of acceptance. The case of acceptance. The buyer loses the right to reject the goods if all or part of the goods are accepted, unless the contract permits rejection after acceptance. If the contract permit rejection after acceptance, the buyer may reject the goods and sue for his losses. Where a breach justifies rejection unless there is agreement to the contrary, the buyer may reject all of the goods or may take those that are not defective, or may take some of the defective goods and reject the rest according to his desire. I mean the buyer's desire, if he actually accepts some of it or reject the rest of it. Recover for damages. Recover for damages. Any claim the buyer may have for damages, a distinction must be made between a claim for failure to deliver and a claim relating to goods that have been delivered. Failure to deliver may cause loss, and the buyer could bring an action for damages. We must distinguish between two cases. The first case, if there is an available market for the goods, the presumption is that the measure of damages is the difference between the contract price and the market at the time the goods ought to have been delivered at the time of the refusal to deliver. This is the first case. The second case, where the goods are delivered and the buyer elects not to reject them, where the breach does not give rise to the right of rejection, it is treated as a breach of warranty, and the buyer may deduct damages from the price itself. Note that the buyer will not be able to claim damages where the loss was not caused by the breach. Now we are going to study or say the duty of the buyer. We said the duty of the seller. We are going to study the duty of the buyer.